And that way I'll be able to rent out my house as a short-term rental.
Depends which one has more square footage than the other.
For 12. All right. Are we ready? And hold on a second. Councilmember Allen, are you ready?
Yes, Mr. Chairman.
All right, let's get this going. I'm going to order this hearing. This is a hearing or roundtable of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Tuesday, January 25th, 2022. The time is 12:14 in the afternoon, and this hearing or roundtable is being conducted virtually. It is available live via the chairman's website, which is www.chairmanmendelson.com/live. I'll repeat that, www.chairmanmendelson.com/live. And it is being recorded so that it is available or will be available on the council's website at www.dccouncil.us. The subject of this oversight roundtable is implementation of DC Law 22-307, which is entitled the Short-Term Rental Regulation Act of 2018. DC Law 22-307, which was adopted by the council in October of 2018, requires the Department of Consumer and Regulatory Affairs to license, monitor, and investigate short-term rentals in the district. Under the law, short-term rental hosts must apply for a short-term rental or vacation rental license endorsement and adhere to prescribed safety and record-keeping standards. Platforms such as Airbnb and VRBO must submit monthly reports to DCRA, that's the Department of Consumer and Regulatory Affairs, for enforcement purposes. And those platforms also must collect and remit all required transient occupancy taxes and maintain all records for 2 years, in addition to other requirements set forth in the law. Final regulations for this law were published in the DC Register on December 3rd, 2021. And DCRA began accepting short-term rental license applications on January 10th, 2022. This roundtable will address the rollout of DCRA's licensing system, interpretation of the regulations, and initial implementation challenges. I want to note, as if I didn't already imply this in the way I started my statement, the council acted 3 years ago. The legislation adopted by the council after considerable debate was enacted without the mayor's signature in January of 2019. That's 3 years ago. And the council pressed almost immediately, I believe it was in 2018, for the zoning commission to amend its regulations, which, if I remember correctly, the zoning commission did on an expedited basis. And yet it still took 3 years for the executive to implement its regulations. But here we are, and the subject of this hearing is to see how we are doing with implementation of the law now that individuals are finally able to get their licenses. I do want to note one other thing. The committee report that accompanied the legislation when adopted by the council made clear that what we were seeking to do was to enable the legal use of short-term rentals in the district, which were by and large on a widespread basis illegal, as in violating the zoning regulations. The committee's intent was to, the council's intent was to allow but regulate the practice of short-term rentals that is already widespread in the district, and to strike a balance in doing so. The balance is between permitting residents to produce income from their properties without commercializing our neighborhoods, between increasing transient use of the district's housing stock while limiting the impact on the long-term rental market, and between supporting short-term rentals yet minimizing complaints about party houses and strangers coming and going from the vacant house next door. For homeowners, we limited short-term rentals to homeowners, and for homeowners, the burden was intended to be minimal. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Tuesday, February 8th, 2022. Anyone who wishes to submit a statement or comments, or who's testifying today and wishes to expand on their statements, has 2 weeks. That is until 5 p.m. Tuesday, February 8th, 2022 to do so. With that, let me turn to my colleague, Councilmember Charles Allen, if you have an opening statement.
Thank you very much, Mr. Chairman. Let me note my thanks for your leadership several years ago, actually, on this bill, as you've noted, as well as for holding today's roundtable. I'll be honest, this was, I think, one of the longer and more detailed debates of legislation that we've had at the council. But the council very carefully weighed some controversial policy questions, listened to a lot of stakeholders, and yes, made compromises, some of which I didn't agree with, but that's what a legislature does. We make policy decisions based on our constituents' interests. We weigh as many of the impacts as we can foresee, and then we hand off implementation to the executive branch. In this instance, there was an additional step of ensuring that the zoning regulations were consistent with the policy choices that we, as the legislative branch, made. The Zoning Commission worked quickly to amend the zoning regulations such that now the zoning regulations seem to be consistent with the council's legislation. I think that was an important step, as you noted. For a long time, DCRA had been issuing licenses for short-term rentals despite the zoning regulations prohibiting that use in residential areas. This is why it was so important for the council to enact this legislation and for DCRA to implement the policy choices the council made. For many years, most short-term rentals were operating illegally, and it was up to the council to actually create a system such that residents could operate short-term rentals in their primary residence while the homeowner is present with a few restrictions. I'm glad that DCRA is now taking applications, and I look forward to talking more with the director about how this process is working thus far, as well as highlight some concerns that I have with the implementation that I don't believe is consistent with the legislative intent of the law that we passed. And I look forward to getting into that more with the director through the hearing today. So thank you, Mr. Chairman, and I appreciate it.
Thank you, Councilmember Allen. So what I'm going to do is we have 8 witnesses before we get to the director. I'm going to invite all 8 into the hearing room. They are David Rivera, Brian Seligman, Larisa Wells, Patrick Bryant, Charlotte Perry, Sharice Crawford, Colin Johnson, who's representing the DC Association of Realtors, and Aaron Childers. Each of you will have 4 minutes, and if you're in gallery view, I believe you will see the timer at the top of your screen. We are changing our technology a little bit, so we have a different timer, and I'm in a slightly different place than I usually am, and you will see how all this works, but please be mindful of the time. Let me just check with staff for a moment. So why don't we begin with Mr. Rivera? Again, 4 minutes, and good afternoon. Thank you for being here.
Afternoon, Chairman Mendelson. Thank you, the committee as a whole, and thank you, Councilmember Allen, for giving me this opportunity to speak. My name is David Rivera, and I am a resident of Ward 6. I have hosted my short-term rental for 7 years and have lived in the neighborhood for 12 years. I intend to live in my basement unit of my row house and rent the upstairs unit. Recently, I was alerted that DCRA intends to prohibit such an arrangement and that it will require homeowners to reside in the, quote, primary portion of their home in order to be licensed for either a short-term rental license or a vacation rental license. This requirement has no basis in either the statute or the regulation. I followed the legislation closely 3 years ago, as you mentioned, Chairman Mendelson, and in nowhere in the legislation that the DC Council enacted to regulate short-term rentals does such a requirement exist. Moreover, in the past year during the rulemaking process, never did DCRA draft, propose, or discuss or provide a comment on any regulation or requirement that homeowners must reside in the quote primary portion of their house. I believe that amounts to an overreach at best by the DCRA. In the past week, I've tried to apply for both a short-term rental license and also a vacation rental license on the DCRA website. However, I did not complete the online application because DCRA requires that I attest that I reside in the primary portion of my row house. I do not intend to make such a attestation. Therefore, I am not likely to be granted a license, even though I am eligible under all the statutory requirements, and I will likely suffer an injury of either reduced revenue or regulatory fines. I understand that the DCRA bases its conclusion on this primary portion of the house on its interpretation of a zoning law, which contemplates the principal use of a building. The principal use of my house is for residential living, whether it's for myself or for my Airbnb guests. Regardless of whether I live in the basement or in the upper unit of my house, the principal use of the house is still residential living. For purposes of illustration by contrast, the row house behind me has the principal use of being a daycare. So even if the owner lives in the main portion of that building at night, the principal use of the row house is still a daycare. So using the zoning law definition to interpret this short-term rental law does not make sense to me. Thank you for hearing my testimony, and thank you for your consideration. Thank you.
Thank you, Mr. Rivera. We're going to go through all the witnesses, and then we may have questions for some or all of you. And I'm aware of the issue, so I'm sure that we will be pursuing that. Mr. Seligman?
Hi. Good afternoon, Chairman Mendelson. Thank you for putting this together. I feel like I sort of late here to the party. We so this issue relates to the homestead aspect of the rental law. We have been following this along since it initially passed. We bought our home in 2018 and renovated upstairs and actually lived in our English basement apartment. And so I was following this closely. I for whatever reason, didn't think this was going to be an issue. But the rules define primary residence as property eligible for homestead. And we believe this definition should be revised and just very narrowly expanded to include properties that are not eligible for homestead, provided the property is owned by a single member LLC, so long as that owner or managing member is a full-time resident of the property and does not claim homestead for any other property. So you spoke at the beginning of this about sort of the spirit and intent of this act, and this still falls within that. The spirit and intent is our position here. You know, owning a home here is expensive, and it is for us. Our plan to rent the English basement, I joke with my wife, what was it that you liked about this house before we bought it? And I think it's nothing, but the one thing we agreed on was the basement apartment. It has a 2-bedroom, 2-bathroom that we saw as our opportunity to own a home. And so, you know, we were really born to do this. Since we've started renting, we love doing it and sharing the city with guests. The rules as they're written, or as the rules have been written by DCRA here, they're overlooking a very narrow segment of homeowners who are unable to obtain a rental license for their property despite falling squarely within the policy goals of the Act. And so our request is that you consider the following. The primary residence should be revised and narrowly expanded to include properties not eligible for homestead, provided owned by a single member LLC, so long as the owning managing member is a full-time resident of the property and doesn't claim homestead anywhere else. And so in practice, homeowner hosts who are full-time residents and wish to obtain a license despite not being eligible for the deduction should be permitted to meet the definition of our primary residence by providing, you know, any sort of documentation deemed relevant by DCRA voter registration cards, federal state tax returns, driver's license, car registration, literally anything is fine to turn over. Personal attestation that we don't claim homestead anywhere else in the district or in any other state or country. And a notarized attestation even from neighbors saying that we're here, that we live here all the time. I would say there's other requirements in this act that require similar types of what I would consider sort of unofficial proof, but I think this satisfies and it allows people that own that, like we own our house through a single member LLC, not through bare title and not in a trust, which we actually did with the intent of renting our basement. So we really, I don't know if I got bad advice, but we really tripped over ourselves and we knew that we weren't going to qualify for homestead. And I was willing to pay more tax and not qualify for the deduction, knowing that it would allow us the freedom to with our other business ventures, et cetera, with a good insurance policy to have the protections that we need. And I put in here in the statement I submitted that after reading the committee report on law, I went through everything. I've been working on this for the past 2 years. It's clear that the language around primary residence and homestead was intended to prohibit non-resident investors, as you said, from operating these things. And I put some quotes of that in here. I don't want to run out of time, but we think that say a single member LLC where the sole member of the LLC is a resident of the house. We're here all the time and we're unable to get a license simply because we don't qualify for homestead. I'm happy to pay more property taxes. We just want to get the license. And this is now a situation in which we're going to have to sell the house and move without this opportunity to continue this business. So thank you for your time and consideration. I'm happy to answer other questions.
Thank you, Mr. Seligman. Larisa Wells.
Thank you, Chairman Mendelson and council members. My name is Larisa Wells. I'm a DC native with my early years in Southeast rental, and many decades later, I bought in 1998, I bought a DuPont Circle row house and gutted it and renovated it. I acquired a C of O for 3 units and held a basic business license to rent out the 2 other units. 8 years ago, when both of my 2 apartment tenants moved out, I furnished them, started renting the 2 units as short-term rentals. I primarily rented to longer-term guests, workers on temporary assignments, students in exchange programs, actors in Kennedy Center productions. I even hosted a professor from the Pacific Isle of New Caledonia who is a World War I specialist here studying using the Library of Congress her first time in the States. So lots of interesting people. All of them were great guests. I filled in between these longer stays with shorter stays. But for the past year with the impending restrictions, I transitioned exclusively to the longer term month minimum. I helped with the rollout, being a test case for the STR license, because I intend to rent a room in my my primary residence. However, I would like to place on record some comments about the restrictions that currently exist, with some minor adjustments. First, the decision to make any rental 30 days or fewer fall under short-term designation instead of 29 or even 27 to cover each month of the year is an unnecessary restriction that negatively affects common case. Several of my guests per year are in transition to be DC residents. They want to rent in a neighborhood and then look for an apartment for more permanent housing. Leases most often start on the first of the month and end on the last day of the month. Please consider adjusting this to the number of days to cover any month of the year. Second, the law addresses accessory dwelling units of basement, apartment, or carriage house as examples, but would exclude those who have both. Row houses are often divided into 3 units, and city services such as garbage collection distinguish residential from commercial as 3 units or fewer. Allowing short-term rentals in row houses with 3 units or fewer would not significantly be different than those with 2 units in the same footprint. If necessary, you could restrict so that only 1 ADU could be used for short-term rental, However, disallowing any use to be used as short-term rental simply seems arbitrary because it's 3 units versus 2 in the same footprint. Third, having 3 different licenses for 3 different uses of the same space is confusing and costly. Someone who rents to short-term guests in an ADU year-round, who leaves town on occasion, and who might have a guest who wants to stay 31 nights would currently require 3 different business licenses. If the STR and the VR could be combined into one, it seems that that would be an improvement, and better yet, rolled all into one variation of the basic business license. As for the process of licensing, I did, as I said, I helped prototype the rollout, and it's evident that the DCRA staff have worked hard to implement the laws given to them, and I applaud their efforts. Thank you for your time today.
Thank you, Ms. Wells. Patrick Bryant.
Thank you very much. I appreciate the time and the fact that the folks are listening. I am a resident of Ward 6 and certainly highlight many of the same concerns that have been raised by previous folks. I would certainly see a need to change regarding living in the basement and renting upstairs. That's something that my property allows as well and makes sense. I find all of the laws to be very restrictive and want to talk specifically about the homestead requirement. I do own the house and I live in the home, but I cannot homestead due to time spent in my home state for political purposes. We rent the home out on a short-term basis and we paid a lot of taxes in the process. Clearly, there's a market demand for these type of properties, and we have no complaints from neighbors, no negative impact, and have used extra rental income to further increase the value of the house through renovations. And I would say to those that are hoping to be restrictive in the law that while you're trying to block having large owners and very commercialized way of doing that, while I understand and think that also makes sense, meeting your goals is not necessarily working in this particular case, because I would ask that there be an exception for members of Congress, staff members of a member of Congress, and district residents, spouses, and dependents, presidential appointees, diplomats, those that are working in DC, serving our country, and having a real impact with their property taxes. That exception is allowed for parking permits, and I certainly see it as something that would make a lot of sense in this particular case. I'm active on Facebook groups and other spots with DC residents, and on behalf of them, I'd like to also mention the need to allow those that rent their particular house. This law is punishing those that have a right to make additional income on their home as an effort to block one particular thing. We're blocking those that rent and have homes in other states and serve our country because we're trying to keep people from applying for more than one property. I think it would be easy enough to allow one particular resident that's paying property taxes to be able to have one particular rental. And if that means they're able to spend the night in the home while a guest is there, such as being in a basement or even renting a basement while staying in the primary part of the home, I feel like all of that would solve the problem without punishing those that rent or that are coming into the district. So I certainly would look for other ways other than homestead to make sure that happens. And I would ask for an exception to homestead, perhaps something using your lease or your papers detailing your work that keeps you outside of the district as better ways to allow those that own their property to make the rental income that they have previously been able to make. thank you for your time. I appreciate the compromises that you make, and I understand completely. And I hope that my comments will at least inform those. Thank you.
Thank you, Mr. Bryant. I don't have a copy of your statement. If you want us to have it for the record, please submit it.
Understood.
Charlotte Perry.
All right, can you hear me?
Yes.
Great, so I'm Charlotte Perry. I jumped onto Airbnb with Obama's first inauguration. So I am the longest continually operating property owner in Washington, D.C. on Airbnb. 24 months later, I started a business, an LLC, managing properties for Washington homeowners for short-term rentals. So I would venture to say I'm also the longest continually operating property manager on Airbnb. At any one time, I am managing between 35 and 45 properties on Airbnb within Washington, D.C. I serve a very valuable service, or provide a very valuable service to both Washington, D.C. homeowners and property owners, and also to the guests who are coming into Washington, D.C. to see and experience our nation's capital, or they're coming in for medical reasons, they're coming in for family reasons, education, internships. I believe my other colleagues, Larisa Wells, has mentioned quite a few of the reasons that people come into Washington. And I would say actually everything that everyone's mentioned are experiences that I'm dealing with right now as well. So the first thing let's back up, through 2021, you needed a basic business license for a single family residence to operate a rental in Washington. Now with 2022, we have the short-term rental license. So the first thing I did was take all my properties and divide them into two categories. Who is short-term, who's vacation rental, who continues to be a long-term property. And a number of my properties already had 6 and 12 month or 1 month minimum stays. And then the properties that have to transition now from being able to rent short-term to strictly over 1 month minimum stays. So looking at those 4 groups as we transition with the implementation of this new legislation, these are the needs that I'm seeing. First of all, in the ones that are short-term, are eligible for short-term rental and vacation rental, the issue with those is that we've been told in the last 2 seminars that you have a 30-night minimum stay, or rather 30-night maximum stay. And so what they're telling us at the office is if that person needs to extend over 30 nights, you can't do that. So basically what the short-term rental office is telling us now is that we have to kick the guest out at 30 nights. That's not correct. They're telling us if you want to rent over 30 nights, you have to have a long-term rental license. There is no such thing as a long-term rental license. All rental properties in Washington, D.C. are required to have a basic business license for a single family rental. That is so, and you need to have that license to apply for a short-term or vacation rental license. So people that, or rather properties that are eligible for the short-term rentals are also licensed for a long-term rental. So that's the first thing that needs to be clarified. Again, the Office of the Short-Term Rental is telling those that acquire the short-term or vacation rental license, they cannot take a stay over 30 nights. So that's incorrect. Next, we look at the properties that are have always been long-term rental. They've always had a 1 month or 6 month minimum stay. Those properties need to be allowed to remain on Airbnb and VRBO, but simply not bookable for stays under 30 nights. So I want to make sure that just because you don't have a license, that you are still eligible to put your property on those platforms. just with a 30-night minimum stay. They shouldn't be kicked off the platforms. I've had stays for 2 years that have come off Airbnb. The next tranche is the properties that are now transitioning. So they are the properties that are not eligible for a short-term or vacation rental license. So they have to transition. Now, the biggest issue is what to do about all the bookings that we already have. And we do not have a clear answer on that. All the bookings that came in up to through the end of 2021, I have bookings for graduations in May, for spring break, for families, for summer vacation rentals. These people have paid in full for those vacations. One $15,000 for a 3-week stay, paid in full. So what do we do with those rentals? Those people should be allowed, those visitors to DC should be allowed to keep their bookings. They booked through Airbnb or VRBO or directly. We, in good faith, accepted that booking. Just to think that what we don't want to do is have collateral damage in the rollout. There is no need to harm the visitors to our city. So I'm saying, let those bookings remain on the calendar. I don't know what the law is, but I imagine, they made the reservations before the legislation was announced. The next question is what to do about, sorry?
Ms. Perry, I asked everyone to be mindful of the clock. You've now been testifying for 6 minutes.
Oh, sorry.
I don't have a copy of your written statement, so that also puts me at a disadvantage.
Oh, I uploaded it on Friday.
Okay.
I'm sorry if I didn't do it successfully.
Well, I'll check with staff. In any event, if you could conclude your statement, please.
All right. So just to wrap up, again, it's this period between, I want you to consider the period between January 10th and April 10th. What happens to the bookings that come in during that period? April 10th, we have a cutoff. No further bookings can be made for short-term rentals.
Okay.
We just don't have any direction from the short-term rental office.
Thank you. Let me go on. I think Sharice Crawford is not here. Colin Johnson.
Good afternoon, Chairman Mendelson and Councilmember Allen and Committee of the Whole and staff. My name is Colin Johnson. I'm a Ward 3 constituent real estate broker and member of the DC Association of Realtors, DCAR. DCAR and our over 3,000 members are a voice of real estate professionals, small housing providers, homeowners, and renters who live and work in the district. Thank you for the opportunity to submit my comments today, and more importantly, thank you for calling this urgent roundtable. The DC Association of Realtors is deeply troubled that DCRA's implementation of the short-term rental regulations has hampered district residents, homeowners from exercising their property rights within statutory and zoning guidelines, specifically allowing homeowners the latitude to decide which part of their home, the accessory or the principal area, may be used as a short-term rental. Concerning legislative intent, no language remotely suggests that homeowners shall only use the accessory unit of their property for short-term rentals. In the code, I'm not going to read that, but it's 30-201.01. A short-term rental is defined as paid lodging for a transient guest with the host present unless it is a vacation rental. The short-term rental operates within a portion of the host's residential property. Additional legislative boundaries include that a short-term rental must be the primary residence. If the owner's ADU and primary residence are shared with the same tax ID, the entire property should qualify as the primary residence. Further, with what is allowed in the zoning regulations, Title 11 subtitle B-32, as amended, defines accessory as use that is customarily incidental and subordinate to the principal and is located on the same lot with the principal use, except for short-term rentals, unless otherwise specifically permitted. An accessory use shall not be limited to 20% of the gross floor area. We are attempting to understand DCRA's perspective as it relates to limiting homeowners to renting out the smaller of the two dwelling units to preserve the distinction between principal use and accessory. Prior to amending the zoning regulations, the use argument may have been effective. However, the regulations clearly provide an exemption to short-term rentals and accessory use. At the moment, prospective STR applicants' only remedy is to file an appeal with the BZA. This process can take months and tons of money to realize and place an undue burden on homeowners, which, as you've mentioned, was not the goal at the time of making the legislation. DC residents purchase properties with the accessory units with the intent of utilizing them as a source of income, whether it's to help subsidize mortgage, plan for retirement, to help pay for children's college tuition. Homeowners ought to be able to use their property as provided by the law. With SDR enforcement slated to begin on April 10th, DCAR implores the council to take action on this issue. Thank you again for your leadership, and we look forward to any questions that you might have.
Thank you, Mr. Johnson. And I believe Aaron Childers is not here. So we'll have one round of questions. Usually it's 5 minutes. Be a little bit relaxed there. I'm sort of saying that to Councilmember Allen. When the director comes and testifies, I'm going to ask him about the this primary use interpretation. I don't agree with him on that. I'm also going to ask him to reach out to Ms. Perry with regard to your concerns. I didn't completely follow your concerns. You said something happens on April 10th?
Yes, can you hear me?
Yes.
Yes, so that's the date that we can no longer take short-term rentals if the property is not licensed.
Okay.
All right, but is that deadline the date we can no longer take or no longer host? Because the reservations have come in already.
Well,
well out into the future.
Ms. Perry, any properties for which there is a reservation, they should be licensed. So they should get a license. I heard you testify about that. So
yes,
a reservation might have been made last year or 2 years ago. Those properties should get licensed.
but they have the BBL, of course, but now they are no. So the problem is they're no longer eligible to rent short term. So some properties are not eligible to get the license,
Well,
but they've already accepted rentals out into the future.
They've accepted rentals for more than 30 days.
Under 30 days. That came in last year. So
Why would they not be eligible for short-term rental?
Well, because we have incredible restrictions on short-term rentals. Not every.
You mean as in they are not owner occupied?
Correct.
Okay. Well, I'm not going to give legal advice here, but the law was adopted in 2018, and the law made clear that in order to be lawful, the property had to be owner occupied.
And also get a license. So I've been following this very closely since 2018. And in fact, I went to the hearings at the time. And we've been waiting for, the ability to license properties to get clear descriptions of what will and will not qualify. So those were, everything was announced and the office was opened on January 10th. And, my goal is to make sure all my properties come into compliance. What I want to avoid is just the mass collateral damage to all the families that booked vacations through Airbnb, through VRBO, and they've paid in full for those vacations. There is nowhere else to move them.
I'm not in a position to give legal advice. The council, all of 2018, so we're talking about 3.5 years ago.
Yes.
Adopted legislation that said that in order to be lawful, one had to have a license, and the license was only available for owner-occupied properties. So if somebody booked after that and not in compliance with that, I would suggest that's a risk that they took. I'm trying to think if there's anything else I wanted to say there. If they're eligible for a license, then they should get the license.
Yes.
If they're not eligible for a license, then that's a risk they're taking. I would also note that until we adopted the law, and in fact, until the zoning commission acted in 2019, short-term rentals in residential zones were violating the zoning regulations. So what we did, what the council did in 2018 was actually to make lawful thousands of short-term rentals. So to the extent that there was some risk,
Yes.
property owners took, that's a risk that they took. But I will ask Mr. Charapa if he would make a point of he or his staff reaching out to you to go over in more detail your concerns.
Thank you. I appreciate it.
Councilmember Allen, do you have any questions?
Thanks, Mr. Chairman. Thank you all for your testimony. I guess a couple of quick questions. Mr. Johnson, I think I heard you testifying to this, Mr. Rivera, and a couple others as well. My concern, as I kind of highlighted here, is that there is nothing in the legislation or the legislative record that would say that if you were to have the basement, essentially your English basement, be your primary residence, that you are unable to be able to use short-term rentals for the remainder of that primary residence. I think we all get our heads around this. We understand the law that was a compromise was that it has to be your primary residence, but we did not specify which room within your primary residence you had to be inhabiting. Is that, I guess, to Mr. Johnson, Mr. Rivera, to both of you, and then Mr. Seligman, I'm going to come to you with a kind of related question. But to Mr. Rivera, Mr. Johnson, that lines up with your approach and your testimony.
Councilmember Allen, this is Colin Johnson again with the DCARB. I was part of the initial discussion of Airbnb in 2018. I do recall a discussion point about the 20% rule, specifically because I think there is language within the code that this is how a primary versus non-primary is defined. However, that being said, as you and I understand, our living circumstances within our city don't always align with that, nor, as I related in my comments, if the intent is to make sure that it's a primary ownership, the easiest way to do that is with the homestead deduction or element, because the only way to obtain that is through being a primary residence. And so I think if the council is concerned about not having overreach or defining exactly what percentage of the home can be used, the simplest way to do that is to define it through the homestead.
Okay. When I'm looking through things, I am looking, for example, the council's legislation, zoning commission's regulations, anywhere it explicitly states a homeowner can only use a certain portion of their home for short-term rentals. I'm not seeing that. And that's what I'm trying to get at to help understand that. Mr. Rivera, anything else you wanted to add on that?
Yes, Councilmember Allen. I also participated in the rulemaking, the discussions in 2018, and I recall the discussion being anywhere, as long as the owner is anywhere on the lot. I believe you may have even brought that point up as and maybe I'm recalling it wrong, but that's the discussion I recall. Is like, as long as you are on the lot, then you would be within the confines of this regulation. But I agree with the previous speaker, who, in that I think the homestead deduction is just a very easy way for the enforcer to see whether it's an ownership or owner occupied or not. Which room you're residing in seems to be a bridge too far in this issue. Thank you.
I agree. And I think that's, to your points, I think that's consistent with my recollection. I think it's also consistent with the legislative record here. Mr. Seligman, now you brought up an interesting piece, which is, and I want to make sure I understand this. So as I understood your testimony, you reside on the property. It is your primary residence. You made a choice from the legal ownership structure. And so if I understand what you're saying is essentially you've made that choice. I'm not sitting on decisions of the factors of why you made one choice versus another. Could have everything to do from perceived liability risks, everything else. But so that you made that decision, and your argument is the language should be amended to follow the same intent, that you have to live there. It has to be your primary residence, but the legal structure is what you're kind of arguing, right?
Right. And even the chairman was even talking, you say, we were throwing around casually the term owner occupied, right? Sort of, we're using that in place of homestead sometimes. And they mean the same thing, but also I'm a case of them meaning very different things, right? In that this is my only home. It's the only house that I own anywhere. And it's the only house I've ever owned. And we made a conscious decision, yeah, exactly, to title it in a single member LLC. So even then, I mean, it's effectively, it's a pass-through entity, right? So it, for all intents and purposes, it would say, I mean, in the eyes, I guess it doesn't matter here, but in the IRS, it's no different. And so, but we are ineligible for homestead. But I'm here 365 days a year. And I can promise you that, especially since COVID and we had a kid last summer, I'm not going anywhere ever. And so we are the intent of what this was designed for, is to people to buy a home, to have, you know what I'm saying? And we love doing it. And so but we can't get a license now because of the homestead issue. But I can hand over anything you wanted, or you can sit outside my house and watch and see that I'm here 365 days a year. That's the issue. And I understand I'm probably, the smallest demographic of people that are hurt by this. But this is a major issue for us.
Okay, I appreciate it. I know I'm out of time, so I'll just say, I think from part of what I'm going to be trying to think about throughout the day is like, what's the plain language element of what was the intent, and kind of what were the policy ideas that we had to achieve that intent. And the intent was clearly, we wanted people to live on the property. We wanted people to live. That was the overarching decision, was we wanted people to be there, not be some absent person who's just not there at big chunks of the time. And I do just very quickly, Mr. Chair, I'll turn it right back to you. But I've heard the 20% rule referenced a couple of times, and just want to reiterate, zoning commission exempted short-term rentals for that, and I think that's something I just want to kind of keep coming back to as we go through this, as we think about what did we mean by primary residence, and I think the legislative record's pretty clear on that. Mr. Chairman, thank you, I appreciate it, and thanks to all our witnesses.
Thank you, Councilmember Allen, and yes, thank you to each of you for your testimony and your time. I'm going to turn now to the director of the agency. So you all will be excused from this panel room or participant room, but you'll still be able to watch the hearing. Thank you again. And so the next witness is Ernest Trapper, who's the director of DCRA. Mr. Director, it's taken us about 3 years to get here. It's good to see you.
Great to see you, Chairman.
When you're ready.
Okay. Just adjust my settings for a minute. Good afternoon, Chairman Mendelson, members, and staff of the Committee of the Whole. I am Ernest Trapper, the Director of the Department of Consumer and Regulatory Affairs, DCRA. My testimony today is about the implementation of Law 22-307, the Short-Term Rental Regulation Act of 2018. I appreciate this opportunity to discuss the implementation of this law with the committee and the roundtable participants. I also want to acknowledge Councilmember Allen. DCRA began accepting short-term rental license applications on Monday, January 10th, 2022. As of January 21st, 2022, DCRA has issued 106 short-term rental licenses and 25 short-term vacation rental licenses. In my testimony, I would explain how DCRA solicited committee input to ensure a successful implementation, and how we've worked hard to make applying for a license as simple and as fast as possible. And I'll provide a brief overview of our enforcement strategy. Following the passage of the Short-Term Rental Regulation Act of 2018, which went into effect in October 2019, and the Zoning Commission's ruling to amend the zoning regulations in light of the new law, DCRA began drafting regulations to implement the law. After consulting with the Executive Office of the Mayor, the Office of the Attorney General, to ensure that regulations were constitutionally sound, DCRA issued the first notice of proposed rulemaking. The proposed rulemaking was published in the DC Register on October 16, 2020, for a 30-day public notice and comment. DCRA received over 100 comments from members of the public and industry stakeholders. In response to the comments we received, the agency made substantive and technical changes to the rulemaking, which required DCRA to publish a notice of second proposed rulemaking. This second proposed rulemaking was published in the DC Register for the second round of a 30-day public notice and comment on February 19, 2021. DCRA received over 30 comments from residents and industry stakeholders. As with the first and second round of comments, DCRA determined that additional substantive changes to the rulemaking was necessary, and the Office of the Attorney General concurred that a third proposed round of rulemaking would be needed. As a result, DCRA published a notice of third proposed rulemaking in the DC Register on May 28, 2021, for another 30-day comment period. After reviewing the comments received during this round of public comments, all of the changes that DCRA made to the third proposed rulemaking were technical in nature, which allowed the agency to publish a notice of final rulemaking on December 3rd, 2021. Prior to publishing the final rulemaking, however, DCRA had been working with major booking platforms over the course of several months to have prospective hosts test the application system to make sure it was simple and easy to follow, and to work out any issues with the application system prior to its launch. Specifically, DCRA partnered with the two largest short-term rental booking platforms, Airbnb and Rivera, to pilot DCRA's licensing application, with close to 50 participating residents testing the system. The pilot program was largely successful, with over 60% of the participants able to get fully licensed for short-term rentals. Those who did not receive a license either abandoned the application or were ineligible due to the homestead requirement. DCRA also hosted a public information session on December 29, 2021, for the purposes of introducing to the public the short-term licensing platform before its official launch on January 10th. We received lots of positive feedback from members of the public who participated in our public information session. One participant stated that she appreciated the public outreach and explanations regarding the new regulations for short-term rentals. Another participant noted that the subsequent follow-up responses from DCRA were accurate and to the point. In addition to this public information session, DCRA also held an information session for DC Council offices and another one for the major booking platforms in late December. Other public outreach efforts that DCRA made to inform the public about the implementation of the regulations include short-term rental user guide, press release, email blast, social media posts, and media interviews. DCRA has worked hard to make sure the process for applying for a short-term rental license is easy and fast. To apply, residents simply visit our website at dcra.dc.gov/short-term rentals. All of the information they need is available there, including the link to start the application process, FAQs, and a link to file complaints about unlicensed rentals. Once an application is submitted, our team will immediately review it. And while the speed of approval will depend on the volume, we are currently able to approve licenses on the same day the application is submitted. Recognizing the financial hardship that many district residents have endured due to COVID-19 pandemic, Mayor Bowser is committed to keeping district licenses affordable. With that in mind, DCRA set the fee for the 2-year license at $104.50, which is significantly lower than similar licenses in other cities, such as San Francisco, where the cost is $450. Thus far, DCRA has received positive feedback from the community about the ease of the application process and DCRA's responsiveness in answering questions. For example, customers have told us that it was professionally done, with one customer saying, "I was impressed how quickly I got a response from DCRA. The people I dealt with were kind, respectful, and professional." Another customer told us, "Thanks for making the short-term rental process so easy. I applied and in 24 hours, got my license for my house. It was great. I appreciate it." In an effort to give the public time to comply with the regulations, DCRA has instituted a 90-day grace period. During this grace period, which began when the platform launched on January 10th, DCRA will not take any enforcement action against residents who are renting their property without a license. This gives people until April 10th, 2022 to obtain their short-term rental licenses. After that, people who do not have a license or are not otherwise in compliance with the law will be fined. Civil penalties for violations by a host range from $250 to $1,000. DCRA has a robust system in place to handle complaints and how they will be investigated. In addition to being able to make complaints on our website, DCRA has a 24/7 hotline set up to handle real-time issues and complaints from residents and visitors. Once a person calls the hotline to report a complaint, it is recorded in our system and is automatically sent to our Consumer Protection Unit database, which we call CPU. Our CPU team will follow up by getting more monitoring and compliance information and may go in person to inspect the property. Anyone can look up whether an address has a short-term rental license by using DCRA Scout system, which is our consolidated online platform to verify licenses and permits. DCRA is also prepared to ensure that host and booking platforms comply with the law. For example, the vendor that DCRA hired to build the licensing platform has a feature that monitors active listings by scanning the booking platforms for addresses and cross-referencing them with addresses in our database. If there is no license for a given active listing, a notification will be sent to the address informing the person that they need to come into compliance by getting the license. Additionally, we will request booking and occupancy data from booking platforms to perform audits on our compliance and monitoring process. For example, we want to be sure that hosts who have a short-term vacation rental license are not hosting for more than 90 cumulative days in a given year. In closing, I want to emphasize the time, care, and thought that went into the rollout of DCRA's licensing system for short-term rentals, as well as our careful analysis of the regulations in the context of the law that was passed by Council. I hope my testimony has given insight into the implementation of the Short-Term Rental Regulation Act and the many steps DCRA has taken to ensure a successful execution. Thank you for the opportunity to present this testimony. I'm available to answer any questions the committee may have.
Thank you, Mr. Trappa. So we'll have at least one 10-minute round. We'll see how that goes. At the end of your testimony, you talked about being able to scan the booking platforms for addresses and cross-referencing them. But if I remember correctly, the law is written such that a short-term rental platform has to post the license number with the listing. And so that should be, I would assume that the large platforms will be complying with the law because they know they have to post a license. So your need to scan should be minimal. I'm not saying you shouldn't. I'm just saying it should be minimal, correct?
It's part of our strategy. So the extent to which we find issues will dictate how often. But out of the gate, I wouldn't say that would be where we would spend most of our time. So yes, your point is well noted that it could be minimal.
You said you did a pilot program and the 29.5% of the participants abandoned their license application. Is there a red flag there?
At this time, we don't see it as a red flag because it was a pilot. We wanted people to feel comfortable, provided us with information. And prior to implementing the full system, we didn't have a reason to go back and say, apply for a license now. However, as the deadline of April 10th approaches, we will be checking for those who have not received their licenses and take appropriate action.
At the time that we adopted the law, which was in October 2018, the committee report said on a given day, there are approximately 1,000 short-term rentals advertising their availability on a web-based booking service platform. And there's an estimated 9,000 short-term rentals operating in the district. According to your testimony today, you've issued 106 licenses. I don't know if it's cumulative plus 25 or that includes 25 short-term vacation rental. In any event, that seems like a fraction of the number of short-term rentals that are out there. Is that concerning?
Not at this time, Chairman. We think, based off the early findings, that as the deadline gets closer, we will see a rush of applications. We would love for everybody to get licensed now so that we can pace work and ensure that we can honor very good service levels in terms of turning applications around faster. But people do have time. And with additional efforts around raising public awareness about the deadline, the program, the availability, and also people hearing from our customers who've gone through the process, we think we will see an increase in our license applications. So it is too early based off what we've seen so far as the evolution of the law, the program, and implementation for us to be concerned about people applying.
All right, I'm hopeful that there won't be such a crush that the system will crash on April 10th. Let me turn to some other issues. Although let me just kind of add to what I just said. So I appreciate that you've done outreach. Perhaps you could press the platforms to turn it up a little bit to get their customers, to their hosts to come in earlier. All that would be advantageous to pace the applications.
Absolutely, Chairman. That's a valid point. And that is something that we are having conversations with our partners to ensure that they also amplify the message. And I think when they also start taking additional steps around compliance, the hosts who use the platforms are going to expedite their efforts to come into compliance with the licensing regime.
I'm debating here. I want to ask the question about this interpretation of primary, but this is an issue that Councilmember Allen and I, as you know, both wrote to you. Councilmember Allen is sort of taking the lead on this, although I'm familiar with it. So I think rather than my pressing questions on that right now, I'll save that for Mr. Allen, but then I'll come back and because I'm want to make sure that we get a better outcome there. So I guess I'm putting a pin in it and leaving it for Mr. Allen. Is DCRA having an issue with the determining whether a property is eligible for the homestead deduction?
There's not a significant issue that I'm aware of from the applications that we've seen so far. But if there is an issue to one of the testimonies, I'll be happy to look into it.
No, there wasn't to the testimony. We designed the law such that it should be pretty easy for your folks to be able to cross-check with the Office of Tax and Revenue to see if the property has the homestead. And if it doesn't have the homestead, then there would have to be some time taken to see whether the property is eligible. I would be shocked if there are very many properties in the district that are eligible that are not taking the homestead because it's worth hundreds of dollars to homeowners. One What metrics or performance measures is DCRA using to track how smoothly the new system is operating?
There are a few that we are paying attention to. One is the level of friction in going through the application process. Another is the turnaround time of our license applications. And the third will be customer feedback. In terms of our customer feedback, it's been largely positive around the ease of using the system. And in terms of turnaround time, based off our existing volume, we are turning license applications around in 24 hours, or pretty much like, within a day. Now, that is likely going to change as the volume increases, but paying attention to the service levels and aligning our resources to ensure that we provide best service to our residents is something that is important to us. And that is how we are managing the process so far.
I meant to ask this question earlier. How many applications have you received? So you testified you've issued 106 licenses. How many applications have you received?
We've not had any denials yet. We've had 106 short-term and 25 vacation rental. So that brings the total to 131.
Yes. We've received several emails, and there was a witness today who were concerned that they may not be able to honor bookings that were made prior to April 10th when the enforcement grace period expires. I think actually I want to rephrase that a little. Bookings that have already been made that will take place after April 10th. When will the enforcement grace, what is DCRA doing to address that?
I want to make sure I understand. It's for booking.
Ms. Perry testified about how there were folks who made bookings a year ago. And I assume you heard that testimony.
Yeah.
So to the extent there's an issue, what is DCRA doing about it?
At this point, we feel the law is the law. It is clear what is allowable, what is not allowable. So the marketplace should be able to sort itself out. If somebody made a booking 4 years, 3 years, 2 years ago, I mean, we are where we are. There's no grandfathering provision in the law. So I'm not in a position where I can tell that person, you can move forward with those bookings. The platforms will be taking some action, and we'll also be taking action to ensure that everybody's in compliance.
Of course, if they're eligible for a license, they should get a license, correct?
Absolutely. That's the number one thing.
Would you reach out to Ms. Perry, though, and either you or somebody on your staff work with her to go through her concerns?
Absolutely. Hearing her testimony, there are a few things in the FAQs that we have on our website that should resonate. So we'll make sure that she gets a follow-up, and we can better understand how we can assist her, given what we know so far.
And you know that you're confident that you know how to reach her?
My staff will be able to figure that part out, Chairman.
Okay, I'm probably going to have a few follow-up questions, but I'll turn to Councilmember Allen.
Thank you very much, Mr. Chairman. And thanks, Director. I appreciate your time here today. Let me also say I appreciate the quick response that you had sent to Chairman Mendelson and myself when we wrote for clarification about the implementation, in particular the decision around the what part of their own home the homeowner can live in. And as the chairman kind of teased up, I'm going to kind of focus my questions on that, but I appreciate the quick response you sent us earlier. I guess my first question is just to clarify, you believe the zoning regulations have been revised to be consistent with the council's short-term rental statute, correct?
Yes.
Okay, thanks. All right, so digging into this a little bit. So you've communicated with some applicants or residents that DCRA's determination is they cannot live in their English basement and use the rest of the home for short-term rentals. And as best I can tell from the response, you seem to be basing that interpretation, at least in part, on the fact that the zoning regulations say that in some instances, an accessory use can only use 20% of a property. But you'd agree that when the zoning commission revised the definition of accessory use to allow short-term rentals, it explicitly exempted short-term rentals from the 20% rule. Do you agree?
I'm not sure. I would agree based off the framing and the sequence of the question, Councilmember Allen. The situation we responded to was for a particular application. And for that applicant, they were not denied. So I'm not even sure how the distinction between principal accessory use had any adverse impact on their status. I don't think it did.
Well, let me try to make sure we understand. So we're kind of working off the same page. So as I'm looking at the second sentence of the definition of accessory use, it states, quote, except for a short-term rental and unless otherwise specifically permitted, an accessory use shall be limited to 20% of the gross floor area. So it clearly says, except for a short-term rental. And that's what my question is. Do you agree, as it states right there, except for short-term rental?
I agree with more than that. And I think it's equally important. And that is, there is an overarching distinction between accessory and principal use. The exception the zoning commission made did not eliminate the need for an overarching distinction. So in implementing the laws and the regulations, we have come up with an interpretation to help preserve neighborhood characters and also honor the overarching distinction. At this time, our position is that if somebody has a problem with that, they should take it up with the zoning commission. There is enough time between now and when enforcement starts in April for us to address this situation based off your letter, testimony we received today.
But you just said you agree that the zoning commission regulations say, except for a short-term rental. So I guess let me ask something else then. Is there anything in the council's legislation or the zoning commission's regulations that explicitly states a homeowner can only use a certain portion of their home for short-term rentals? And here I'm trying to look at the plain language of the statute and the regulations, not the interpretation. Is there anything in the council's legislation or the zoning commission's regulations that explicitly states a homeowner can only use a certain portion of their home for short-term rentals?
I'm not aware.
Okay, I agree. It's not there. Okay. So if DCRA believes that a homeowner cannot stay in the English basement during a short-term rental, has DCRA established a percent, and we've said that 20% rule is exempt. So has DCRA established a percentage of the home that a homeowner can occupy during short-term rentals?
We're asking, has DCRA established a percentage that would help us manage the distinction between accessory and principal use?
Right. So if sounds like we agree, zoning commission says in terms of that 20% rule, except for a short-term rental. So we're in agreement that short-term rentals are exempted from that. So what I'm trying to understand is, and we've also agreed, there's nothing in the council's legislation or zoning commission's regulation explicitly stating a homeowner can only use a certain portion of their home for short-term rentals. So if DCRA does believe that a homeowner cannot stay in their English basement during a short-term rental, what is the percentage that DCRA has established that they are allowed?
I will have to circle back with you, but I also think it's important to go a few sentences back, because the fact that I agree with one statement or the other doesn't automatically mean we would draw the same conclusion. I would ask you, Councilmember Allen, is there an overarching distinction between accessory and principal use that has to be preserved? Would you agree with that?
I think we would have put it in the legislative record in the legislation if we did, and it's not there. And we both agreed there's nothing in the council's legislation that explicitly states a homeowner can only use a certain portion of their home for short-term rentals. We explicitly said we want to use the homestead deduction. We explicitly said had to be primary residence because we had clear goals in mind of that. But we did not say, and we did not put in the legislative record that there was a percentage or a certain proportion of the home that you had to live in or not. This is how you've interpreted it. So that's why I'm trying to pull out of this to understand how DCRA's interpreted this. And respectfully, you've already denied people based on this, and to circle back with a percentage number, I don't understand that. What is the percentage that DCRA would be relying upon here? What's it, and what's it based upon? Is there a statutory or a regulatory provision that you're relying on? Is there a case law that you're relying on? That's what I'm trying to understand.
It's a good question to try to get that understanding. And I think you would also agree that this is a complicated matter. At this time, and for today's testimony, I am not prepared to say we'll be moving in a different direction. What I'm prepared to say is that your comments has been understood, and this is a matter that we will take another closer look at. But nothing changes from the previous communication that we've provided on this issue. And as I recall, as we speak today, nobody has, not a single person has not been able to get a short-term rental or vacation rental license because of the distinction between accessory and principal use, or our interpretation of the regulations and the law at this time.
But Director, you replied to an applicant that they would not be able to. So they have.
I have to check if that person even applied. I mean, it all comes down to going through the application process, and if you are denied, taking advantage of your appeal rights. That's the due process. But for today, I cannot comment any further on the matter.
Okay, well, in the letter, it said that the individual would have to file an appeal, like to go to OAH to file appeals. So that is a denial. And I am trying to make sure we understand, like, of the why, right? Like, so that's from a policy. We're obviously laying out the policy, laying out the legislation. So in our minds, I think we laid it out as clearly as we could about primary residence, homestead deduction, because we had clear goals around that. And I'm trying to make sure I understand the interpretation. Now, if part of what I'm hearing you say is that you're looking into it, that you're trying to interpret as best you can, would that suggest that perhaps if the council gave greater clarity, that would also be beneficial or helpful as you are looking at making those determinations?
Lots of things will be beneficial when we are implementing laws and implementing regulations. As more information becomes available, we weigh that. We've not foreclosed this discussion, and we've not said there's only one way of getting to a solution. So all I'll offer back to you is, yes, we've heard testimony today. We've heard you on your inquiry. We responded. And my commitment to you is I'll review this matter in greater detail because it's very technical. It involves zoning regulations. It also involves legal interpretations. And at the end of the day, when a decision leaves DCRA, I should be comfortable that we are doing the best that we can, given the information that we have.
No disagreement there. I'm trying to think, is there, since you're having to base, as you say, you're basing it on the law, that it might make sense for if the council gave you greater clarity on that within the law. That's my point. That sounds like that's something you'd be open to. So I appreciate that. I know my time is up here. So thank you, Mr. Chairman.
If you need more time, when I'm done, come back.
I don't know, Director, I feel like we wrapped that up pretty well.
Yes, thank you.
I'm going to take
Okay.
I'm going to take a stab at it. So don't go away, Mr. Allen. Let me just say that it's not clear to me how the council could address this issue, because the council was already clear in saying that there was no limitation with regard to how much of a property could be used for short-term rental. Since we were already clear that there's no limitation on how much of the property, I don't know how we could now legislate something to clarify that there's no limitation on how much of a property can be used for short-term rental. I think the reason why Mr. Allen has been pressing on the 20% issue is because when we are drafting whether we're talking about a law or regulation, we're mindful of whether we want limitations. And the zoning regulations have traditionally required for an accessory use that there can be no more than 20% of the property. But with regard to short-term rental, the zoning commission struck the 20% as a cap and did not put another number there. And that is significant. And that really is the point here. So I'm looking at the Office of Planning report to the Zoning Commission on October 22nd, 2019. And the description, which isn't very long, is to permit short-term rentals at residential properties in all zones except PDR as a matter of right accessory use, and to allow a short-term rental accessory use to occupy more than 20% of the gross floor area of the property. That's the explanation. To allow, I'm quote, and allow a short-term rental accessory use to occupy more than 20% of the gross floor area of the property, unquote. So the Office of Planning recommended and the Zoning Commission adopted, striking the cap. And we all know in legislative drafting that if you want a cap, you have to state it explicitly. And if you don't want a cap, then you strike it. That's the significance of that. Mr. Allen, in the letter that we sent to you, cited a BZA case, actually a Court of Appeals case, involving a BZA case, holding that the size of a facility is not determinative in the analysis of whether it is an accessory use, because there's nothing in the regulation implying that a facility loses that character when it reaches a certain size. So the Court of Appeals was clear that the amount of a use, in this case, short-term rental, has any effect in terms of the regulatory restriction, which again, the Zoning Commission chose not to have a restriction. But I want to say more, and that is the council was very clear in the legislation, and the law is very clear, that there can be multiple units within a property that can be rented out on a short-term rental basis. Section 104B, the license endorsement shall be applicable to the property on which a short-term rental is located. The presence of more than one short-term rental at the host's property shall not require separate license endorsements. More than that, and looking at the committee report, and this is elsewhere explicit in the language of the statute, the committee print has no limit to the number of days that a district resident that is a host may short-term rent all or part of his or her property, nor does it limit the number of rentals that may occur on that property. It does limit the number of guests, however, to a maximum of 8 or 2 guests per bedroom, whichever is greater. So it is possible that you have a little old lady in a big house who's renting out 4 bedrooms to 2 people each per night, every night of the year on a short-term rental basis. That she could do. And clearly, the dominant occupancy of that property would be the short-term rental. This is a little old lady. I want you to imagine the tiniest, oldest lady you can imagine who wants the supplemental income. She's got a big house and she rents out 4 bedrooms, 2 people in each of those bedrooms, and there's just her. And yet that's clearly allowed. That's explicitly allowed in our bill. And it is our legislation that the Zoning Commission implemented. So this notion that just because somebody decides they're going to live in the basement and rent out the upper floors has no basis in this interpretation, or has no, there is no basis for this interpretation, that somehow that's wrong. 1 bedroom, this little old lady with 1 bedroom for her and 4 bedrooms for guests with 8 people, or this couple who decides to live in the basement and rent out 2 rooms upstairs. What's the difference? And yet your zoning administrator has, I would say, overworked the statute to somehow read into it that accessory even though the zoning commission took out the 20%, that accessory has to be a secondary use. Actually, what the law says is that it has to be the host's primary residence. You know this, that's what the homestead deduction is about. So it's their primary residence. And how much of it they use on a short-term rental basis is up to them. So square feet can't be the measure because the Court of Appeals upheld the BZA, the square footage is irrelevant. Primary residences can't be the issue because it's already their primary residence. That's why they have the homestead deduction. It can't be the number of renters because the law explicitly allows up to 8 renters for one host. And there's no cap, as we've discussed already, the 20% was deleted. I guess where I'm going with this is I earnestly implore you to go back to your zoning administrator and ask him to rework this, because it's not on his side and it is not fair to say to anybody, well, you can go to the BZA. You can take 8 months of your life, whatever the filing fee is. As you know, deference is given to the agency, so the BZA rarely overturns the zoning administrator. Could happen. That's just asking the homeowner to take on a burden that's unfair when the basis isn't there and the legislative intent is quite clear. So again, I ask that you go back to your zoning administrator and ask him to take another look at this. Mr. Truck, mute or?
No, I was going to be sure you finished. I'm going to take another look at this issue. There has to be a distinction between accessory and principal use. In implementing regulations, there has to be some objective measures as well, so that we're not treating somebody differently because they're an old lady and somebody because they are younger and they look like an investor. We can't get into any of that. Yes, the 20% doesn't apply, but what is it measure now? 100%, 80%, 70%? Like, it is worthy of further discussion and analysis. So my commitment is to revisit this issue and circle back with our position if it changes. And at the same time, there's enough time between now and April 10th when enforcement starts. And as far as I can recall, with respect to application process, nobody has applied that has been denied. So nobody has been adversely harmed. But I do get a broader point that we need to take a hard look at this. And that's something that we will do.
I appreciate that. And let me say that there were a couple of witnesses. Actually, there was one witness and then we received written testimony that they haven't applied because the interpretation they were told makes them ineligible. So that's why you don't have the application, because they said they haven't applied. And I would urge you to get away from the what percent, because neither the zoning commission nor the council contemplated a percent. It has to be owner occupied. And owner occupied means it's their primary residence. So as you know, Mr. Director, a person has to live somewhere. And in order to get the homestead deduction, that is your primary residence. You got to live there. So that is the standard, whether you live in 5% of a mansion or 80% of a little shack. All you have to do is live there. So please get away from the percentage. But I appreciate that you will go back and look at it. I had one other question, but I'm going to see if Mr. Allen has any follow-up.
Thank you, Mr. Chairman. I appreciate your line of arguments, and I think the two of us are trying to be as clear as we can on this. I guess the only question I would have, given the fact that we are looking at both applicants who are, well, we can't call them applicants yet, individuals who want to apply but have been told that they would be found and denied currently, so that's why you don't have any applicants yet. And with April coming, Director, can you give us a commitment of how long and what the time frame will be to come back with an answer?
I think I can follow up after this roundtable with the timeline that we will be weighing, because the issues that we would have to address will not be limited to the distinction and how we're making a distinction. Today, I've heard people talk about, homestead, and people even asking for exemptions. There are different issues, and we want to be able to weigh them all together and make informed decisions. So I commit to getting back to you with a timeline on how we'll handle this, but kindly afford me the courtesy of reviewing the timeline with my team rather than committing to a timeline through this forum.
Okay. I don't think you have to review the homestead deduction. I think someone came in to testify about what they would like for the council to make legislative changes. That's separate from there. To this specific issue, I would ask that we get a timeline back with some degree of urgency, as I think you can tell and hear that it is urgent. So I respect the fact that you need to talk to your team to come back to us with a timeline, but would ask through the chairman if we can make sure that we come back with a pretty aggressive timeline.
Understood.
Okay. Thank you, Mr. Chair. Thank you, Director.
Thank you. And as I'm rereading the OP report from October 22nd, there's one other argument that occurs to me. Reading from the report, to meet the definition of a short-term rental, under the zoning regulations, to meet the definition of a short-term rental, the operator must obtain a basic business license from DCRA. And then the definition of accessory use, I read this before, permit short-term rentals as residential properties in all zones. So all that they're requiring is that one has to have a license in order to qualify in an accessory use, as an accessory use. I had one other question. Could you walk us through the process for a host who wants to get a short-term rental license? And what I mean by that is what documentation must be submitted? How many days should hosts expect? You sort of touched on that. What happens if a host accidentally submits inaccurate or incomplete information? And what steps does DCRA take to confirm information? So can you walk us through the process?
Yeah, I can speak high level about the process. Starting with the question you asked, and that is if there's basically additional information necessary. What we do is we follow up with the applicant to advise them of what is deficient. But before they apply, we have FAQs that list the commonly asked questions and answers to it. But generally, they'll go to our website, dcra.dc.gov/short-term rentals, and then they would create an account. Once they create an account, it allows them to access the application. At the beginning of the application, they'll put in basic information around name, address, and they would attach any relevant documents as it relates to insurance, as an example. And then they will submit. Our team will review the application, and if it meets the criteria that we've established, including homestead eligibility, the application is approved, payment is made, and they get their license. This all happened online. There's no need for someone to come to our office in person. Now, if something is deficient, they'll be advised of what the deficiency is, and we'll have some time period to correct that. And if they correct that, the application is reviewed and approved.
What if the host accidentally submits inaccurate or incomplete information?
So, for example, they submit wrong insurance documentation.
Sure.
We would notify them of that issue, and they'll have an opportunity to correct it.
And your feedback so far is that there hasn't been a lot of friction, I guess, in terms of the application process.
No, in fact, the vast majority of people have complimented the program on the ease of use.
Give me just a sec. I don't think I have any other questions. So with that, I'm going to conclude this hearing. Again, this has been a hearing on implementation of DC Law 22-307, the Short-Term Rental Regulation Act of 2018. The regulations were published in early December. Folks have until April 10th to get a license if they're currently a short-term rental host, or they will, their enforcement action will start to be taken. The record with regard to this hearing, a roundtable, will be open for 2 weeks. Anyone who wishes to supplement their comments or submit comments has until 5 p.m. on Tuesday, February 8th, 2022. Mr. Director, thank you for your testimony. I want to thank the earlier witnesses. We have a hearing at 3 o'clock on vacant property. So I'm going to adjourn this and then I'll see you in about an hour and 10 minutes. The time is 1:49 p.m. and this roundtable is adjourned.